Hello and welcome to this session in which we will discuss how is a corporation born, or simply put, how is a corporation formed for that matter. A corporation is created in a state by filing the proper paperwork. Now the proper paperwork is something called Articles of Incorporation, which we will discuss in this session. As I mentioned in the prior session, most corporations are incorporated, Articles of Incorporation, incorporated in the state of Delaware. For example, farhatlectures.com, and the majority of corporations, especially C Corporation. Why in Delaware? Once again, because they don't have state income taxes. These initial steps are crucial in establishing a corporate legal identity and operational framework for the corporation. For large corporations, we have a group of people called promoters. They lay the groundwork for the business, while the Articles of Incorporation provide the legal backbone defining the corporate structure and capabilities. Now bear in mind, not every corporation needs promoters. All what you need to do to start a corporation is file your Articles of Incorporation. Your lawyers can do it, your CPA can do it, that's all what it takes. But usually, the general idea is this. When you are trying to incorporate, is because you are trying, most likely there's a good chance you're trying to raise money. You want to bring money into the corporation. So what you do, you incorporate. Why? Because you can sell stocks to various people, so you can raise money, stocks, or issue bonds, borrow money. That's the whole purpose of incorporating, or one reason of it is to be able to raise money. So you have those promoters that will do this. So the first thing we're going to discuss is the role of promoters. Again, not all corporations have promoters. farhatlectures.com, small businesses don't have promoters. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
So who are the promoters? Before a corporation is officially formed, there are individuals known as promoters. They're trying to promote, who take the initiative to start the business. Not to start the business most likely existed in some other form, like in a sole proprietorship or an LLC. But now they're trying to start this C corporation to do what? Their main task is to secure money and other necessary resources for the corporation. Promoters means what? It means they are selling. And what are they selling? They're usually selling ownership, stocks, or they're selling bonds. They're trying to raise money for the corporation. Those are the promoters. When the promoters enters into a contract to obtain these resources, which is money, they are personally liable for them. What does that mean? It means if they are lying, if something goes wrong, the promoters are themselves responsible, not the corporation. The corporation don't exist yet. They are trying to promote the corporation so they can raise money, so the company will go public maybe, or form a corporation and bring those new investors and creditors. But if something goes wrong, the promoters themselves are held responsible. For example, just to kind of give you an illustration, if I want to promote Farhat Lectures, I'm going to have to go out there and promote, talk to people, talk to investors if I want to grow the business. I'll be promoting my business. I already have an S corporation, but I'll be promoting to be a C corporation. Adoption of contract by corporation. Eventually the corporation is formed, and once the corporation is formed, most likely it will choose to adopt these contracts because the promoters are part of the corporation itself. This means the corporation agrees to take over the contract and the responsibilities. However, bear in mind, the promoters to be released from those liabilities, a specific agreement must be made called a novation. And we talked about novation early on in the contract. It's an agreement where the third party, the person or the company the promoter made the contract with, which is investors or creditors, agrees to release the promoter from the contract and instead hold the corporation responsible. And usually what happens when you are the promoter, this will be a clause where once the corporation is formed, you agree to release me personally from this, assuming other conditions are met. Now we talked about the Articles of Incorporations. Notice incorporation, not Articles of Organization. Articles of Organizations are for the LLC. Just sometimes they play on words on the CPA exam. So what's included in those articles of incorporation? What's the articles of incorporation? Well, to officially become a corporation, you have to file those paperwork. It's a legal document that creates the corporation itself. Now, what does it include? What's the content of the article? Name of the corporation, the legal name under which the corporation will operate. The registered agent, the name and address of the person authorized to receive legal document on behalf of the corporation. Could be the founder address, it could be the lawyer's address, the lawyer, the law firm that helped you incorporate, or the CPA. Incorporators detail, the people that incorporated the company. Incorporators details, the name and addresses of incorporators, the individual responsible for setting up the corporation, usually the owners. The authorized shares, the number of shares, the type of shares we're looking at, common, preferred, Class A, Class B, Class C. Remember, once we are looking at these different classes, we're looking at a C corporation, because in S corporation, we don't have different classes. We only have one type of class. And why do we have different classes? Common, preferred, Class A, Class B. This is the beauty or the benefit of a corporation, where you can issue different type of classes. Some are voting, some are non-voting. Like the preferred will have preference to dividend, to be able to appeal to different type of financier to give you money. Again, once you see we have types of shareholders, or in articles of incorporation, we're looking at C as in Charlie corporation. C as in Charlie. What's not required in the articles of incorporation? You have to know what's not required, and you're going to see why in a moment. Names of directors, you're not required to put them. Name of the incorporators, you are. So be careful. Type of business, what type of business are you in? You don't have to include that. Business purpose, this is called the purpose clause, and we're going to talk about the purpose clause shortly. You don't have to include, but if you include, you have to be careful. Location of the offices of the business, you don't have to include that. Sometimes you don't have any offices. It's a PO box. It's a virtual business. Now, why do we need to talk about the business purpose, the purpose clause? Well, the purpose clause in the context of corporate formation refer to a specific section where the corporation states its primary business objective or activities it plans to undertake. So if you want to, you could have this purpose clause. So this purpose clause, it spells out in the articles of incorporation, we're in the business of education, we're in the business of landscaping, we're in the business of marketing, we're in the business of software development, whatever we are in the business in the articles of incorporation, a corporation can define its business purpose. This clause outlines what type of activities the corporation is formed to pursue, because they want to be specific. Why do they want to be specific? Because when they raise this money, they want the shareholders, the owners, the potential owners to see we are for this specific purpose. Now, there's a term called Ultra Vires Act. This term in Latin is called beyond the powers. If a corporation engages in activity that fall outside its defined purpose in the articles of incorporation or in activities not permitted by law, these actions are considered ultra vires. Now, why is that important? You're going to see why in a moment. So if a corporation state its purpose will be to open a bookstore, but they start to manufacture cars, I'm giving you an extreme example to kind of make the point where you switch your business, this activity can be deemed ultra vires. Now, liabilities, this is where this is important. Directors or officers who authorize or engage in ultra vires act can be held liable for any damages that these action cause to the corporation. So guess what? Remember, as a director, as an employee, you have no liability unless you are engaged in something the shareholders did not agree to right from the get-go. You defined your purpose in the articles of incorporation, and now you are engaged in totally different business. So this liability is a way to make sure the corporation adheres to its stated purpose and protect the interests of the shareholders and the stockholders. Remember, the articles of incorporation don't have to include this purpose clause, but if they did include this purpose clause, well, they will expose themselves if they change the purpose. So the purpose clause serves as a legal boundary for the corporation's activity. Maybe the new potential shareholders, they would say, I will not invest unless you have this clause. This ensures that the corporation remains focused on its core objective and complies with legal and regulatory standards. That's the purpose of it. As a potential shareholder, you want to protect yourself. So again, this is part of the articles of incorporation, the paperwork that you file with the state, official paperwork. You can have a purpose clause. You don't want to have a purpose clause. It's up to you. Now, we need to be familiar with the term bylaws. Bylaws are totally different from articles of incorporation. Those are internal documents. It's a set of internal rules that guide how corporations operate. Totally different from the articles of incorporation. If you belong to a club on campus, like the accounting club, and if not, you should join the accounting club, hint, hint. Each club will have its own bylaws. Documents created by the organization, by the corporation, that outline the rules and regulation for how it's governed and managed. Can you include these bylaws with your articles of incorporation? Sure you can, but you don't have to. And these rules might cover a wide range of topics, such as the roles and power of the officers, procedures for holding meetings, method for electing the board of directors, different day-to-day operation. These bylaws are typically adopted when the corporation is formed, either by incorporators themselves, people who incorporated, or in the initial board of directors. Here are the bylaws. They agree to them. What would the bylaws typically include? They will typically include the structure and powers of the board of directors. What can the board of directors do? When do we have shareholders meeting? The rights and responsibilities of officers and directors. Procedures for amending the bylaws. If you want to change them, how do we change them? How decisions are made and recorded. Can we modify them? Sure, the board of directors usually has the authority to modify or amend, replace, repeal, whatever. They can be changed as needed, provided these changes are in line, obviously, with the articles of incorporation and the state laws. They don't violate any state laws. But unlike the articles of incorporation, they're not typically filed with the state. Again, they are internal documents meant primarily for the corporation use. We need to be familiar with a term called piercing the corporate veil. Remember when we talked about corporation, and we said one of the major advantage of corporation is the shareholders, the officers, the directors, the people that work for the company, the owners of the company, they have what's called limited liability. They are not personally liable for what? For the debt and the obligation of the corporation. And we said that's most of the time, 99% of the time. Well, how about the exception? Here's the exception. Piercing the corporate veil is a legal concept where courts may decide to treat rights or liabilities of a corporation as rights and liabilities of the shareholders, directors, or officers. Remember, this is an exception to the general rule. So the general rule is one of the advantages of incorporating is limited liability. This is the exception where the legal entity is no longer separate from the owners. The legal entity, debt, and obligation are not separate from those of the owners. Normally, a corporation is seen as a legal entity that's separate from the owners who owns it and manage it. And this separation is why we incorporate. Again, to do what? To get this limited liability. Individuals like shareholders and director not being personally liable. However, in certain such situation, the courts can pierce this veil, holding these individuals personally responsible for the corporate action or debt. Now, we need to know under what circumstances would that happen. Generally speaking, there are 3 reasons for this. One is the commingling of funds. Shareholders are mixing personal funds with corporate fund, or the use of corporate asset with personal use. It blurs the line between the corporation and the individual. Well, when you treat the corporation as your personal bank, well, the court's going to say, guess what? You no longer have personal protection from the liabilities. This could lead to personal liability. So the managers, the owners, they have to keep separate line between themselves and the corporation itself. So that's one reason, is where you commingle funds or assets. 2, the corporation did not have enough money to start with. It's called inadequate capitalization. If a corporation is not giving enough capital to start with to reasonably cover its potential debt and liabilities, the shareholder must be liable. So what you do is, if you form a corporation, remember the accounting equation: assets equal to liabilities plus equity. What is inadequate capitalization? So what happened is, let's assume we were able to raise $1 million, just for the sake of simplicity. Of that $1 million, 900,000 coming from liability and 100,000 from equity. So when we started this corporation, this is thinly capitalized. So $1 out of $10 is coming from the shareholders, and $9 out of $10 or 90% is coming from liabilities. When this company starts, there's a good chance they may not be able to pay their liabilities. The situation often referred to as thin capitalization. And what happened here is the shareholders, they created this organization to do what? To use what's called other people's money. It means let the shareholders hold the bag, because anything that happened, they would only lose 100,000, the shareholders would lose more. Again, those are, you'll have to go to court, prove it was thinly capitalized, so on and so forth, but this could be one reason why the shareholders, they would lose their limited liability protection. The third reason is you started this corporation to do what? To commit fraud. If a corporation is created for the purpose of defrauding creditors, like transferring assets from a sole proprietorship to a corporation to avoid paying the existing debt, the court will hold the individual behind the corporation personally liable. Remember, a corporation is initially a business, and a business is a sole proprietorship, or it could be a partnership, but let's think about a person that's running a business. They accumulated a lot of debt. So what did they do? They form a corporation, and they throw in some assets, but they have a lot of debt, and they brought more investors. They defrauded them. These investors invested. These creditors even pay more money because now it's a corporation. And what we find out is this whole scheme was to do what? For the original owners that created the corporation was to get the debt off their books, in quote, where they're not liable for that debt. If that's the case, the whole purpose of the corporation is to commit fraud. And there are legal consequences if any of these happened. The corporate veil is pierced through the court, and this is a serious action. It means that protection that was provided to you under the corporate status is gone. And this step is only taken when there is a clear evidence that the corporation is being misused to defeat the purpose of the laws or to perpetrate fraud or schemes. So you have to know when this piercing of corporate veil occur. Simply put, somebody trying to defraud someone else through corporation, or the owners or the managers are commingling funds. They're using the corporation as their personal asset. Then you are personally liable. Let's take a look at this multiple choice questions from farhatlectures.com. What is the key requirement in the formation of a corporation? Is it hiring a CEO before filing the articles of incorporation? Is it filing articles of incorporation with the state? Is it having a physical office space? Is it listing all future employees in the articles of incorporation? Let's start with the easy one. You don't know your future employees, D is out. Do you have to have a physical office space? You don't have to have a physical office space. Again, think about a virtual business. C is out. What between A and B? Do you have to have a CEO before filing the articles of incorporation? Or do you start with the articles of incorporation? You start with the articles of incorporation. This is how a corporation is born. You file this with the state. Again, what's the most common state? Is the state of Delaware. State of Delaware. What should you do now? You want to go to Farhat Lectures, look at additional MCQs, whether you're studying for your CPA exam, your accounting courses, or some other certification. Invest in yourself.